persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 24-1382. Alaska Community Action on Toxics et al. Petitioners versus United States Food and Drug Administration and Martin McCary in his official capacity as Commissioner of the United States Food and Drug Administration. Ms. O'Brien for the petitioners, Ms. Neumeister for the respondents.
Good morning, Council. Ms. O'Brien, please proceed when you're ready.
Good morning. May it please the court, Catherine O'Brien for the petitioners. I'd like to reserve 3 minutes of my time for rebuttal, please. This court should hold unlawful and vacate FDA's order maintaining approval for the use of 5 toxic phthalate chemicals as food additives. As FDA explained in the proceedings below, the Food, Drug, and Cosmetic Act makes clear that food additives must be shown to be safe. And FDA acknowledges that under this standard, it must revoke approval for food additives if the evidence before the agency does not provide reasonable certainty that the additive's use will cause no harm to human health. But here, FDA arbitrarily rejected decades worth of evidence showing that the phthalate additives do not meet this safety standard. First,
let me ask you, Mrs. O'Brien, as I see the issues in this case, the first question is standing. Do you want to address that?
Certainly, Your Honor. The petitioners have standing because it is undisputed that FDA's authorizations for the use of the phthalate additives cause petitioners' members and their children to be exposed to these toxic chemicals in their food, and this places them at substantial risk of serious health harm.
So I too have standing?
Your Honor, it would depend on the foods that you eat and
well,
whether—
we're talking about foods like chicken.
We are.
So we're not talking about exotic dishes.
That's correct. Unfortunately, the phthalate additives have— Oh, I'm sorry, Your Honor.
What case you think is strongest in support of your claim of standing?
Well, to address your specific question, Your Honor, about the widespread nature of the harm, I would rely on this court's decision in Public Citizen versus National Highway Traffic Safety Administration at 489 F3rd 1279, where the court held that the fact that many people face a risk of bodily harm does not undermine standing, because the risk of bodily injury is sufficiently particularized, even if it's widely shared. And
do you agree that the two-pronged test in Public Citizen has been set aside, at least in part, by the Supreme Court in the Susan B. Anthony case?
The formulation is different, Your Honor, and I think the formulation is different even in this court's cases. Not all of the cases that deal with a risk of future injury utilize the two-part standard that's articulated in Public Citizen or in the Food and Water Watch case. But I think fundamentally they're getting at the same question, and they're consistent in holding that petitioners have standing where they show that their members are exposed to a toxic chemical because of the challenged agency action, and they have realistic health concerns because of that exposure, as the court stated in the Clean Wisconsin case that's discussed in our briefing.
And so the clearest statement of that is in what, the Akins case, ATTINS by this court?
I'm sorry, Your Honor, the Addius versus Carecruz case?
Excuse me, I'm sorry.
Would you mind repeating the case name, Your Honor?
ATTINS, DC Circuit, opinion written by Judge Griffith.
Thank you.
So that's cited in the briefs, but in any event, it seems to me the formulation that you've just described is what we said in Akins, that it's enough to look at what the harm is and whether the cause is the agency action that you're challenging.
That's correct. In the Addius versus Care First case that's discussed in the briefing, the court affirmed that it's frequently upheld claims of standing based on a substantial risk of future injury. And it held that the court considers whether the petitioner's members face a substantial risk of injury as a result of the challenged action. And here we know that is the case because FDA acknowledges that its authorization for the use of the phthalate additives contaminates food. The petitioner's members attest that they regularly eat and their children regularly eat foods in which the phthalate additives are found. They have specific concerns about health effects from that exposure, including cancer, endocrine effects, and reproductive harm.
Let me ask you, where does EPA acknowledge the foods your clients eat are contaminated?
Well, FDA acknowledges that the approved uses of the phthalate additives contaminate food. If that were not the case, these chemicals would not require approval as food additives. They are regulated.
Counsel, just so you're clear, I took your word contaminated to mean a danger to health. And EPA has authorized these additives in food. And so you're trying to show that it ought to re-examine its position. In other words, I didn't see that the FDA was giving away the case because it has a different view of than you do of what the statute requires in the way of what I think you would agree is at least your burden of persuasion.
That's correct, Your Honor, and I apologize if my use of the word contaminated was not precise. FDA does not acknowledge that the presence of the phthalate additives in food presents health concerns, but they do acknowledge that their authorizations are responsible for the presence of the chemicals in the food. And FDA also does not dispute that it has not considered and has not assessed the safety of these chemicals for roughly half a century. And in the intervening decades, substantial scientific evidence has been developed that is fundamentally—
Counsel, I don't think that's disputed by FDA. What FDA says, as I understand it, it says that it had to decide if the petitioner showed enough for the agency to conclude or find that these additives are no longer safe. In other words, to distinguish the status quo, which says they are safe. And so its response to your petition, and I acknowledge one of the problems you faced was that you started this case with 28 additives, and as the case proceeded, it was down to 5 because the manufacturers stopped producing 23 of the drugs. So didn't FDA explain why your three-pronged approach in your petition was not persuasive?
The agency did explain its view of why the three-step argument in the original petition, the agency did not find persuasive. But that does not relieve the agency of an obligation to rationally consider and determine whether there remains a reasonable certainty of no harm from the use of the 5 additives that remain approved. And
so the agency responds by saying, 1, we're denying your petition, but the drugs of which you're concerned, the additives, I'll call them, are on our list to examine them. And furthermore, we have issued a request for information to get updated data on all of these studies regarding these additives. But it didn't accept your three-pronged approach. And don't you have a burden of persuasion at least? And EPA sorry, I keep saying EPA's, my mistake. FDA explained why it found your approach unpersuasive. It critiqued your theory of how the drugs function. It critiqued your theory about a single standard. And to the extent you were faced with this change of circumstances, it said it was too late to change your theory now.
And in the objections, Your Honor, the petitioners addressed FDA's rationale in the underlying petition denial and explained why it did not provide a reasoned basis for the FDA's decision. And there are essentially three components to that critique, the arguments that were advanced in the objections. Number one, as the petitioners explained, and they bolstered the record on this at the objection stage, the FDA did not consider when it approved these additives that they cause serious health harms to people that are now well documented in the scientific literature. So just to provide one.
It's not denying that. All I'm trying to understand is you came to the agency with a three-pronged petition, and the agency responded saying, one, you got the mechanics of the drugs wrong. Two, we couldn't bunch them all together and just have, a single safe level. And you wanted to change your theory in the middle of the case. Normally, that's the kind of thing under an APA review we would defer to. Now, even under Loper-Bright, there is still under Skidmore a level of deference to agency expertise. And the agency argues here, this is, whether the mechanics of these drugs and how they function, et cetera, is very much a matter of its expertise, not for judges. And this court has previously taken that position. So how do you respond to all that?
Your Honor, I would begin by characterizing the petition differently. What the petition asked was for FDA to revoke approval for 28 phthalate additives that were approved at the time of the original petition a decade ago. Included in that group of 28, of course, were the 5 that we're still arguing about today. As to those 5, the petitioners argued that none of the 5 meets the safety standard any longer, and they provided new toxicity evidence that is specific to each and every one of the 5 phthalate additives that are still approved. So the petitioners
were denying that your petition asked that all these drugs be treated alike. That secondly, based on that, you came up with a level showing what would be, safe or unsafe consumption. That was your theory, wasn't it?
That was the theory. That was the argument supporting the request for agency action, which was the revocation of each of the authorizations. And at the time
Counsel, what I'm trying to focus on is I didn't think there was any dispute about what your original theory was. I thought the problem was the ground shifted under you, and the agency took the position that it was not the stage at which you could change your theory when you're dealing with, objections, that you had to file a new complaint. That's sort of docket control and interpretation of its regulations.
But that interpretation is not supported by the regulations or by the Food Act. The Food Act is clear that at the objection stage, and this is somewhat unusual for petition proceedings before agencies, but it's what the statute provides. The statute provides that petitioners can introduce new evidence at the objection stage, and they can make new arguments at the objection stage. The key is whether the objections are within the scope of the original petition and whether the objections identify errors in the order rejecting the original petition. And the petitioners remained within that allowable sphere here. And we know that because, as I said, We requested revocation for the approval of these 5 additives in the original petition. We presented new toxicity evidence specific to each and every one of them. So that we were not relying on the cumulative effects argument to show that for these 5 chemicals specifically, there is new information that undermines the safety finding. We also provided in the 2016 petition exposure data specific to 3 of the 5 phthalate additives that are still approved. Those were the only ones that had exposure data available. And that data showed that exposure to those chemicals exceeds safe levels. FDA...
Is what you're saying now, is it different from the theory that was addressed in the initial decision, which is that at the time, all 28 are in the case, and then all 28 are treated by your petition, by the argument supporting your petition as uniform, in that they all ought to be seen as in alignment? So there's 28 that are in alignment, and then there's an ADI, acceptable daily intake, I think, that applies to one of them, and it ought to be applied to all 28. And then there's a spread between what's actually taken and the acceptable one, and that ought to be applied across the board too. So it was kind of an across the board argument was what was presented.
That's correct. And that was necessary when we were dealing with the class of 28, because we didn't have specific toxicity and exposure information for all 28. And so the most persuasive case when there were 28 on the table was to make that class analysis argument. And that was consistent with the decision that FDA had just issued concerning PFAS chemicals that it had been used as additives. And that's why the petitioners took that approach. But then FDA took an independent action, as Judge Rogers alluded to revoke approval for 23 of the 28. At that point, any arguments about whether those 23 were safe had become moot, and it would have made no sense for the petitioners to continue pressing their arguments about those 23. Fortunately for the petitioners, their arguments about the remaining 5 were not dependent upon that broader cumulative effects argument for the group of 28. And so the petitioners went forward by simply narrowing the scope of the administrative relief and the scope of the arguments to focus on the 5. And at the objection stage... It
could be, though, that even if the case gets narrowed from 28 to 5 because of the abandonment,
yes,
then it could be that the theory stays the same, which is that there used to be an alignment as to all 28. If there's alignment as to all 28, of course there's alignment as to the subset of the 28, because if all of them are related in the same way, then so is a subset. And then if that's the way that the case proceeds, then there's nothing that changes. It's just that you're addressing the same theory. It's just on a narrower set of phthalates, and that it follows like the night follows the day, because if you were right, as the petitioners were right as to the original 28, then they would necessarily be right as to a subset too. And the case goes forward on that understanding. And then what you're indicating is, though, no, that's actually not what happened or the right way to look at it. At the objection stage, the theory just changes. The theory is no longer that what's left is in alignment in the same way that the 28 were in alignment. There's new evidence that comes into play, and all that can be considered with respect to those phthalates that are still left on the table.
That's correct. And the other thing I think that's important to understand is that the narrower arguments with respect to cumulative effects that the petitioners presented in their objections were responsive to what FDA had said when it denied the underlying petition. And in our view, this is exactly how the objections process is supposed to work. So when FDA denied the original petition in 2022, it said, essentially, we don't buy this broad argument that all 28 are sufficiently related to be treated as a class. What we think would be more supported would be to focus only on a subset of the phthalates that have been shown to have so-called anti-androgenic effects, which means that they interfere with the production of testosterone during fetal development. In the objections, the petitioners narrowed the cumulative effects argument to do precisely what FDA had indicated would be proper, and said to FDA, we seem to be in agreement that there's a group of phthalates that are still approved, that you acknowledge are established anti-androgens, and at a minimum, those have to be considered as a class. And in addition, all of the 5 have new toxicity evidence that establishes, and exposure data that establish that there is no longer reasonable certainty of no harm. So while it may be the case that the regulatory landscape has changed and the strongest arguments we had for the group of 28 are no longer germane, there is still evidence that is irreconcilable with the statutory standard, a reasonable certainty of no harm, and FDA was obligated to consider that rationally. In this regard, I think it's helpful to think about a hypothetical. Let's say that FDA had granted our petition based on all 28, and all 28 were still approved. And it accepted that broad class-based argument, the 3 premises that Judge Rogers described. And then you had a manufacturer who filed objections. They only manufacture 1 phthalate, let's say it's DINP. I don't think FDA would argue that that manufacturer would be limited to responding to the 3 premises that supported our petition. They would be free to make out the case that DINP is safe. And the statute and the regulations are clear that they could introduce whatever new evidence they wanted to at the objection stage, and they might be entitled to an evidentiary hearing. And FDA would have an obligation to consider that evidence fully. So the theory—
I understand, to the extent you're making that argument, that there is a way to read what FDA did as endorsing that. But FDA also critiqued the type of studies on which you were relying, the type of data those studies used. So even if your theory is the same as you say, and you had this data as to the 5 on toxicity, there is this problem that FDA saw as to the nature of the studies. What's your response there?
Our response is that FDA only critiqued a subset of the evidence, and the reasons that it gave for rejecting that evidence are contrary to the evidence that is actually in the record. And this court, while giving appropriate deference to agencies, repeatedly has held that the agency must provide a reasoned basis consistent with the evidence before it for rejecting the evidence.
So as I understood the FDA's position, and maybe I misunderstood it, on your overall approach with the 28, they explained why they didn't, or were not persuaded by your theory that all of these should be treated the same. It also said that aside, there's a problem with the nature of the studies on which you're relying, and it explained why. So moving to the objection stage, I understand your point about you just continued and you had new toxicity evidence. But what about the concern that FDA had with the nature of the studies?
FDA identified 2 purported defects with the toxicological evidence specifically, but neither of those is consistent with the evidence before the agency. And under this court's precedent, for example, the LA County versus Shalala case, that is not a reasoned basis for denying the objection. So first,
I understand the point about if it's not supported by the evidence in the record, but that was not the nature of your objection.
The first objection, Your Honor, argued that FDA did not appropriately address the new toxicity studies, that established numerous health effects that FDA did not consider when it judged the chemicals safe. FDA claimed—
You're more familiar with the record than I am, but I thought, and FDA can explain when it has a chance to argue, that the defects it found in the studies that supported the 28 in the original petition remained even as to the 5.
So FDA did have a couple of particular critiques, and I would like to explain why they are not rational. They criticized the toxicity evidence and also the exposure evidence. They said two things were wrong with the toxicity evidence, neither of which is rational. Number one, they said that it was not appropriate for the petitioners to rely on epidemiological studies, which are studies that document adverse health effects in human populations associated with exposure to a toxic chemical. FDA says in this proceeding that epidemiological studies generally are not useful for risk assessment. That's at JA9. But as we explained, that attitude towards epidemiological studies is contradicted by FDA's own approach when it looked at the evidence concerning the most widely used phthalate additive, DEHP, in 2012. In 2012, FDA conducted an assessment of the toxicity evidence on DEHP, relying heavily on epidemiological studies, and concluded that but neither did the petitioners here, Your Honor.
So that was the concern about the epidemiological studies, but there was a second concern.
The second concern, which I imagine you're alluding to, Your Honor, was that the petitioners supposedly didn't provide dose response studies. These are the animal studies that are used to establish the level of exposure to the chemical that's associated with a toxic effect. But FDA's statement is simply incorrect. As the petitioners pointed out in our opening brief, we provided numerous dose response studies, which are cited at page 38 of our brief. And after we pointed this out, FDA sort of pivoted and said, okay, it's not that there were no dose response studies, but supposedly the dose response studies are deficient. But again, the reasons that FDA asserted for this supposed deficiency are flatly contradicted by the record. So first, FDA said that the dose response studies were not appropriate because they supposedly only addressed mixtures of chemicals, which FDA said would not allow the agency to determine whether a particular phthalate additive caused the toxic effect observed. But that is simply not correct. As we explained at page 20 of our reply brief, if you look at just the abstracts of those studies, they make clear that they did assess mixtures, and they also assessed and provided dose response data for individual phthalate additives. So this is not...
Yeah, here's what's troubling me. There's a dispute here as to whether or not the petitioners submitted enough for FDA to conclude that it should vacate the rule. Your position is the statute only requires you to raise serious questions, that you don't have a burden to prove that the additives are unsafe, that's the FDA's burden. But from the court's perspective, are you asking us to review these studies and basically find that there was clear error by the agency when it evaluated the animal studies and the human studies? That's what I'm trying to understand in this analysis. I don't see this as a case where, did the man fall on the sidewalk and break his leg? But rather, there is some expertise involved. And EPA doesn't, I have EPA on the mind because there was an EPA case, but the FDA does not view the types of studies for these 5 drugs enough for it to conclude that the petition has shown enough that it should vacate the rule and disrupt what it describes as, the status quo. That it views you as having a heavier burden than simply raising questions. And it makes an argument based on the statute, purpose, the structure, the history, EPA's interpretation, and it distinguishes the EPA case, the other drug which was an initial authorization case where the FDA actually set some conditions. So I'm just wondering, what is the court's role here? Under an APA, I mean, if it's an error of law, that's one thing. But now we're talking about judgments about technical studies. And your argument, as I understood it, is it's just flat clear that any reasonable person would understand that you raised enough of an issue that FDA ought to go so far as to vacate its current rule.
So if I may, Judge Rogers, I think there are three important points to respond to your question. So first, there is an error of law here. As Your Honor referenced, the FDA applied a legally erroneous burden of proof to the petition, requiring the petitioners to provide essentially quantitative proof that dietary exposure to the additives exceeds an established safe level. And there is no basis in the Food Act or FDA's regulation for applying that burden. Instead,
It talks about full studies, though.
and full studies were provided, hundreds of them, Your Honor. In addition, we provided authoritative assessments from FDA's peer regulators, including the Consumer Product Safety Commission, which concluded that phthalates that are still approved by FDA do not meet a reasonable certainty of no harm standard and banned them from children's products despite finding that the main source of exposure to children is from food. We also provided 2 declarations from leading experts in the health effects of phthalates and exposure to phthalates who synthesized the evidence and concluded unequivocally that the ongoing use of these chemicals in food is presenting severe health risks to children and other members of the population. So there is a legal error with respect to the burden. In addition, this court has...
I started out there by asking, I assumed, but maybe I was wrong, that you do not agree that you have the burden of persuasion. And the question is the burden of persuasion of what?
Yes, we agree with FDA's statements in the record and in its brief that revocation petitions have to establish safety questions that are significant enough to support a finding that there is no longer a reasonable certainty of no harm. So it's not any question, it's not any one study, as FDA used as a hypothetical in its brief. The questions have to be significant enough to make it untenable to have a certainty of no harm. But that still is different from proving quantitatively, as FDA demanded here, that exposure in food is exceeding a safe level. That's where we part ways with FDA. But even assuming that FDA is correct about the burden, it did not make a reasoned decision based on the evidence in the record. And I think it is helpful.
Can I just ask you just quickly on the burden?
Sure.
Question? So, so you're agreeing that you have have a burden.
Yes.
You have a burden to raise significant questions. You've raised questions that are significant enough to support a finding that there's no longer reasonable certainty of no harm.
Yes.
That burden exists, and that's a burden of. That's not just a burden of production. That's you have to introduce materials that substantively get you past the threshold.
Agreed.
Now, there could be some disagreement about what the threshold is, but I actually don't think there is. I think everybody agrees what the threshold is, which is that the questions have to be significant enough to support a finding that there's no longer a reasonable certainty of no harm. So with the decisions, as I read the decisions, both the first one and the second one in response to the objections, they did encant the right standard.
They did.
They encanted it several times, and then they encanted it in their conclusions too. And the conclusion would be, therefore, there's not significant enough evidence that there's no longer a reasonable certainty of no harm. lots of negatives and lots of qualifiers, but I think
Yes.
that's roughly right. So it's not that the standard was articulated incorrectly or was not articulated correctly in its conclusion. Then where's the legal error?
The legal error is in the application of the standard. They did not, in fact, apply that sufficiently significant question standard. And I think there's two ways that we see this. Number one, there are statements in the record that are inconsistent with the articulation of the standard that Your Honor just offered. So, and we've cited them in our brief, including in the order at JA6. FDA stated that petitioners had to prove that, quote, dietary exposure levels from the approved uses exceed a safe level. So that, I submit, is an example of them articulating a standard that's inconsistent with what they recited elsewhere. But I think it's actually most concrete if we contrast FDA's decision here with its decision revoking approval for what we refer to as the PFAS additives. So in that decision in 2016, FDA revoked approval for existing additives because the petitioners provided new studies that were not even specific to the chemicals at issue, but new studies on related chemicals showing that there was evidence of reproductive and developmental harm. And FDA acknowledged those studies and said they had a lack of data that was specific to the additives at issue that could resolve the safety questions presented by the new studies, and a lack of data to quantify exposure. And because they had new evidence of toxic effects from related chemicals that they thought was relevant, and they didn't have either more specific toxicity evidence or exposure evidence to resolve those concerns and conclude that the ongoing use was safe, they revoked approval. Now, FDA's order said that the reason for the different outcomes is because there supposedly was not comparable evidence here. And I would agree, the evidence here was orders of magnitude stronger. So in the PFAS decision, as I mentioned, FDA had no toxicity studies specific to the three chemicals that the petitioners were asking to revoke. But here we have studies for each of the 5 phthalate additives that documents that those specific chemicals cause adverse health effects. In addition, FDA, as I noted, with the PFAS additives said, we don't have data to estimate dietary exposure. We don't know how much of these chemicals people are really eating. But here, in contrast, the petitioners presented multiple lines of evidence indicating that real-world dietary exposure does exceed safe levels. So the evidence here is substantially stronger, the record much more extensive, and the reason that we have a different result is arbitrary decision-making.
Let me make sure my colleagues don't have additional questions at this time, and we will give you some time for rebuttal.
Thank you.
Just one or two from me. This is Judge Katsas orally. You do not dispute, I'm taking you back to standing. The risk of harm must be substantial in an absolute sense. It's not enough if exposure increases a cancer risk from 1 in a trillion to 2 in a trillion on the theory that that's 100% increase, correct?
I think that's correct, Your Honor. We agree that the increase in risk has to be substantial. And here we know that the increase, sorry.
No, but the absolute risk has to be substantial is what I'm more interested in.
As opposed to the increased risk? Yes, Your Honor, that's correct.
Okay. So that's a very open-ended standard. What help can you give us in thinking about this question of substantial risk where we're talking about long-term exposure to something that might in the distant future present a substantial health risk? Your best cases on standing on this point, I think your best case on standing on this point involves ozone, which is very different, right? You breathe ozone and your lungs get irritated, and that's an Article 3 injury. That's easy. seems more akin to public citizen in the sense that the causal chain is very long and hard to assess. So how do we think about substantial risk in a case like this?
Your Honor, I would submit that this case is on all fours with the many cases I was discussing earlier in which the court has held that exposure to a toxic chemical attributable to the agency action can support standing. And so, for example, in the California Communities Against Toxics case that we discuss in our briefing, that case was about an exclusion from RCRA regulation for certain hazardous waste facilities, and the petitioner's members lived nearby. And they asserted that they had concerns about health consequences from looser regulation of those hazardous materials. Not necessarily that there was going to be an immediate health effect like lung irritation, but rather that they would be exposed to greater levels of toxic substances, which also would be associated with diseases that might have a long latency period. This is frequently the case in in cases that this court adjudicates after finding standing that involve exposure to toxic chemicals. Moreover, it is the case here that the phthalate additives can pose acute health risks. So it's not necessarily the case that the time period between exposure and effect is long. But even if it is long, this court has frequently found standing in such cases. For example, any case involving exposure to a carcinogen, the exposure is going to be remote in time from the effect, but where the petitioners establish, based on their declarations and evidence in the record, that the exposure gives rise to realistic health concerns, the court has recognized that that is an Article 3 injury. And I think it's helpful to contrast the cases that FDA relied on. The problem in the cases that FDA relied on, such as the Food and Water Watch case, was that the court found that the petitioners were speculating about whether the action they were challenging was really going to increase their members' exposure to the substance or the activity that they alleged was causing them harm. But here, there's no need for that speculation because we know that FDA's authorizations are causing the phthalate additives to be present in food that petitioners' members eat right now. So they're experiencing exposure that's current and ongoing.
So showing of exposure plus concern of harm, reasonable fear of harm?
A substantial risk, Your Honor. And I would assert that in this, I'm sorry.
No, okay, that's helpful. Thank you.
And I think what's key in this case, Judge Katsas, is that we're not relying on the subjective concerns of the petitioner's declarants, but rather the expert declarations in the record and the other evidence that establishes that exposure at realistic levels from the foods petitioners' members and their children are eating does pose risks of serious health harm.
Can I ask you one follow-up on that? And I don't, but Judge Katz, if you were going to follow up, go ahead. But if you were going to shift
I'm all set. Thank you.
I have one follow-up on standing, which on this, which is that there's a general principle in standing law that we assume the merits in favor of the person who's seeking relief. And so in this case, I'm not completely clear in my mind on how all that works out, because at some high level, your merits theory is, look, there's these additives that are unsafe, and or at least there's no reasonable certainty that they're safe.
Mm-hmm.
And so you need to do something about it. You, the agency, needs to do something about it. And for standing purposes, do we take that underlying merits theory as a given that you're right about that, and then we measure standing assuming that baseline? Or do we not take that as a given? Because in some ways, asking you to show that there's a substantial risk of harm is similar to the ultimate merits, which is your theory is you should shift things in that you should no longer leave these authorizations in effect and you should repeal them because there is a substantial risk of harm.
Yes, I think that's absolutely correct, Your Honor. And I think as the court has held routinely, the court does assume that the petitioners are right on the merits to assess standing. And here, that would require the court to assume that it was arbitrary for FDA to conclude that there are not health risks associated with the ongoing use of the phthalate additives under these authorizations. So that for purposes of standing, the court does have to assume that there are health risks, significant health risks arising from the ongoing use. Here, to be candid, we don't feel we need to really lean into that assumption because the evidence in the record is very strong from independent experts that the risk of harm is substantial. But you are absolutely correct that the presumption does apply, that we're correct on the merits.
Because some of our decisions and some of the decisions in the area do articulate the requisite showing on the part of the party seeking relief as a burden to show harm, or at least a risk of harm. Mm-hmm. And in cases in which the merits inquiry is about the risk of harm too, it's just not entirely obvious how those interrelate. If there's an independent Article 3 obligation to show a risk of harm, but if the merits then is also bound up in the risk of harm, then it's not entirely clear to me how all that washes out. But the way you're looking at it is to say, you assume the correctness of our theory on the merits, which is that these phthalates need to be regulated in a way they haven't been so far, precisely because of the risk of harm that they pose.
That's correct. But I think even if the court determined it has an independent obligation to establish, without that assumption, that there's a substantial risk of harm, the record and the declarations amply support that.
We make sure there's no further questions at this time.
No, not for me.
Okay, thank you. We'll give you a little time for rebuttal.
Thanks.
Ms. Neumeister.
Thank you, Your Honor, and may it please the court, McKay Neumeister on behalf of the government. In authorizing the use of phthalates as food contact substances, FDA determined that there was a reasonable certainty that such use would not be harmful. Petitioners have not carried their burden of disturbing that determination or of demonstrating Article 3 standing to pursue this petition for review, and their submissions are inadequate on both standing and the merits because they haven't made an adequate showing regarding a lack of safety and because they're operating at a high level of generality that doesn't satisfy the robust showings applicable in these circumstances. To disturb the status quo and require FDA to repeal existing authorizations, it was not enough for petitioners to submit some new studies that raised questions about safety in the abstract. Rather, they had to submit sufficient data to establish a finding that there's no longer a reasonable certainty of no harm. The sufficient safety questions that they have to establish are sufficient because they demonstrate that there's no longer that reasonable certainty, and they have not adequately supported that finding here. Now, I'd like to start.
Isn't that standard quite extreme, though? Substantial showing. I mean, there are those double knots, but I mean that there is no longer any harm. I mean, that's what they say all their studies showed. And FDA just chose to reject that showing and decided to go its own way through the request for information. Whereas the petitioners are saying, we've met our burden of persuasion under this standard to raise substantial questions with this double knot requirement. And my question in this case would be, what more could anyone show to meet the standard as FDA has suggested it is here? Because if the petitioners are right about your own rules allowing a petitioner essentially to start all over again at the objection stage, then a lot of these procedural points and docket control and deference to the agency disappear.
Yes, Your Honor. So in order to satisfy their burden, the evidence that they're putting into the record and relying on has to be enough that would justify a finding that there's no longer a reasonable certainty. And when you're asking that question, you have to work within how FDA analyzes safety and does its risk assessment. And that's what they did in their petition in the first instance. Their food additive petition acknowledged the burden and attempted to show that there were these sufficient questions undermining the reasonable certainty by comparing the acceptable daily intake to the estimated exposure. And that's one of the ways that FDA in general looks at this safety and risk assessment, by comparing those two values. The petition tried to do that, and if they had succeeded, then there would have been a reasonable question if they had shown that based on this new evidence that was adequate and scientifically supported, that there is a reason to believe that the actual daily exposure to these substances exceeds a level that is safe based on scientifically supported evidence, usable evidence based on these internationally recognized guidelines that FDA applies. If they had done that, then there would be these reasonable questions. But the agency explained for 3 reasons why they failed to meet the burden that they had set out to meet in their petition. The first was because they were pursuing solely a class-based analysis where they were looking at.
I understand that. My question is based on the assumption, and you can tell me that assumption is wrong, that at the objection stage, you can start all over again. So at that point, they were only dealing with 5 drugs. They looked at 5 drugs, 5 additives, and they introduced exposure data, and they introduced expert evidence, and they introduced studies. So my question is, if that is procedurally correct, which I did not understand your brief to accept, and that's why I said, assume that is correct, then why haven't they met their burden of persuasion along the lines that the chief judge was discussing?
So it is not procedurally correct that they can do that, Your Honor, and I'd love to address the many reasons why. But assuming that they could reframe their petition this way at the objection stage, it's hard to even accept that premise, because the analysis would have been very different. But even if they could, they have not shown by acceptable evidence that meets these international guidelines for what is adequate science that FDA applies in assessing these studies. They have not shown that there is this no longer reasonable certainty. But just stepping back, in their petition, they sought a class-based analysis, and they specifically—
Are you going to procedurally why it's not permissible to do this?
Yes, Your Honor.
Okay, so before you do that,
Okay.
before you do that, I definitely want to hear that, but before you do that, does the agency decision in response to the objections do the even if analysis, which is that even if procedurally it's okay to proceed in this fashion, the evidentiary stuff that was introduced at this stage still wouldn't be sufficient?
So it does address the new studies that they put into the record and explained why those are not sufficient. I also just want to note, for the first time before this court, I'm hearing that they now want FDA to do an individual analysis of each of these 5 chemicals separately. That is not something that FDA understood them to be asking for in their objections, and it's not something that we understood them to be asking for in their brief. We don't read their brief to say that FDA's action was arbitrary and capricious because it didn't separately assess DHP and DINP and DIDP and each one separately and look at the reasonable certainty with each one separately. They've always been pursuing a grouping analysis and relying on cumulative risk.
But groupings that are different from the original 28 at the objection stage, at least.
They are
Still a grouping, but not not individual is the point here.
Yes, and they proposed a completely new grouping that is outside the scope of the original 28 phthalates in their petition. And that's not just a difference in evidence in the record. That's a different action that they're asking for that requires a different kind of scientific analysis. And you can't short circuit the process by proposing that at the objection stage so that the agency can't seek public comment on that new analysis and can't perform the relevant science and give them an opportunity to object to it. It's very complex scientific assessments that go into this process, which is why if you're going to propose something that is outside the scope of the initial petition and outside the scope of the denial order, it has to come in a new petition. I also just want to highlight in their original food additive petition, and this is at JA 966 to 67, they specifically explain that they are asking the agency to repeal the authorizations for all of these phthalates as a group. And they are specifically saying that they are not asking the agency to go on a one-by-one basis. They say, quote, removing the approval for one orthophthalate may result in its replacement with another one that is less studied and that may pose similar or greater risk. They were specifically waiving any argument that they wanted the agency to proceed on an individualized basis. And so FDA has never tried to engage in that analysis here. And if it did so, it would look very different than the scientific analysis that it has put into this proceeding. Let's see. So fundamentally, that's why there is this issue with the sort of new proposed action and new grouping coming at this late stage of the proceeding. But that's just one reason why FDA ultimately rejected their petition and overruled their objections. So there was the grouping issue with the 28 phthalates that we explained scientifically that kind of grouping was not supported. Their objections don't take any issue with the explanation as to the 28 phthalates. The state of play is different now, but the agency also looked at the remaining 5 phthalates that were within the scope of their original petition and explained why that grouping analysis also wouldn't work. And so the kind of class-based analysis that they have been seeking throughout is not the kind of thing that the agency can do in this case. The agency also looked at the 2 kinds of specific evidence, the toxicological data with respect to acceptable daily intake and the exposure data, and explained why on both of those bases, the original petition was scientifically deficient. With respect to the acceptable dose intake, one very clean way to understand why what they were trying to propose was not adequate is that the agency identified that there are studies of the phthalate at issue, DEHP, conducted in non-human primates, which are a better proxy for the kind of risk that you would expect to see in humans, that those non-human primate studies would have supported a much higher ADI level than the one that they were proposing in the petition. But petitioners simply did not account for that at all. And when you do not have a full set of reports on safety in a petition, that can unfairly bias the outcome in favor of a particular result. And that's the kind of thing that FDA can't permit in this process. And I think stepping back, it's helpful to just think about the fact that FDA is doing these analyses using a particular kind of approach to this evidence, using these internationally accepted guidelines and asking these questions a specific way that ensures that the science is good and will support these safety determinations. It couldn't make that determination with respect to the ADI in their petition. With respect to the exposure analysis, there were similar issues. The petition essentially picked exposure numbers from a couple different studies and used the ones that were greater than the ADI without actually explaining why those underlying studies were a representative sample of the American diet and were the kind of studies that could be used to conduct this analysis. One of the studies was from the UK and was outdated. The agency explained that that kind of study might involve different supply chains. There might be different exposure levels. And it's not to say that that study can't be used, but they didn't do the work to explain why it was in fact appropriate to use here.
Now, you've seen in the briefing, and then you heard this morning also the notion that the way the agency went about its analysis can't be reconciled with the way it went about the analysis in the prior proceeding involving, I guess it's called PFAS. Is that the way we pronounce it?
Yes. And so
okay.
It's, each of these proceedings is going to depend a lot on the kind of substances at issue and the studies that are available and the kind of inferences and qualitative assessments that can be drawn in a particular circumstance. The PFAS proceeding involved only 3 chemicals. We were dealing with a lot more chemicals in this case. And in the PFAS proceeding, there wasn't quantitative data available as to exposure and the migration of these chemicals, but the agency determined that it was able to make a qualitative assessment based on biopersistence. And it was very specific to the record in that case, determined what evidence would actually be required to undermine a reasonable certainty and what evidence they didn't need because they could reach that same conclusion on another basis. That's not something that the agency can do here. In the FAP, petitioners specifically tried to do the normal general analysis that FDA uses in these circumstances, which is comparing an ADI to an EDI. And FDA reasonably explained why their comparison simply didn't work. The values they were proposing didn't hold together, were not adequately scientifically supported. Now, in their objections, petitioners switched tack and essentially instead of trying to support the values they had previously proposed or explain why they thought the agency's analysis of those values was wrong, they just abandoned them entirely. They didn't address the non-human primate studies that FDA flagged as a problem with their ADI. They didn't address the UK diet study. They didn't address an Australian and Canadian study that FDA had flagged as potentially more valuable to them and potentially could produce exposure values that they could rely on. They didn't do that at all. Instead, they just tried to flood the zone with a bunch of new studies and pointing out various things that they say the agency didn't adequately consider. But they didn't rebut the specific errors that the agency originally identified. And by switching tack and sort of approaching it at this higher level of generality, it just underscores that their understanding of their burden in this case is not the way that it has been understood and applied by the agency. It's not enough to have a bunch of safety studies that could raise questions about that might be relevant to safety. The evidence you put in has to itself justify the finding that there's no reasonable certainty of safety. And FDA explained why they hadn't done that and that there were numerous issues.
I don't want to completely quibble, but I'm going to for a second. So you use the formulation justify a finding, and you use that a couple of times, which I totally understand. That's what the standard says is articulated to support a finding. And one can imagine that there's an inquiry under which, and as I understand, I don't think anybody disagrees on this. It's not that the statute or the regulations actually set out what the standard is supposed to be. It's just in the decisions.
Yes.
Right? So it's just the agency could shift it over time. They could treat the words as meaning one end of the spectrum of what that word could bear, or they could treat it as coming down on the other end of the spectrum of what that word could bear. But the word that's used is support. And so one possible conception of support is it's kind of like, you just have to introduce admissible evidence that raises some question. And the way you're talking about it is support as in what would not quite compel, but would justify. And I'm just wondering, it seems to me that that's different from just could conceivably support in one set of scenario by some individual.
Yes, Your Honor. So I want to take the text on its face, but I also want to have an opportunity to speak to why the agency's understanding makes sense given the overall statute and the process here. The text of the standard is not just support a finding, it's significant enough to support a finding, which indicates that it's not enough that it tends to support or is consistent with the conclusion, that it is significant enough that it can support that finding, which in this circumstance means justify the finding, that the finding can be made on the basis of this evidence. And that understanding of the standard is consistent with how the overall statute and this process works. So food additives are deemed unsafe before they're authorized, and that's 348A. Yeah. They're deemed to be unsafe unless the agency then issues a regulation authorizing safe use. So at that point in time, the status quo has flipped. They go from being deemed unsafe to having a safety determination after a proponent meets the heavy burden of demonstrating that it will be safe, that there's no reasonable certainty of harm, of no harm. And so after that happens, the status quo shifts. The default presumption is not that these are unsafe anymore. They are authorized. And in order to disturb that status quo, petitioners have the burden of any petitioner walking into an agency and demanding agency action. The burden of persuasion is on them to require the agency to repeal what it has already authorized. And so consistent with that general allocation of burdens and the fact that the statute says they're unsafe until the agency acts, the burden is on them to put enough evidence in the record that the agency can then conclude on the basis of that evidence, there's no longer a reasonable certainty. They have not done that. So in this case,
Are you invoking our AUER deference on reading of that regulation?
I'm not, Your Honor. Just to be clear, the language that we're discussing doesn't even come from a regulation. It comes from the agency's decisions. And no one disagrees about the wording of the standard. And
the word support.
Yes, that doesn't come from a regulation. That just comes from the agency's decisions. If you look at JA 1676, it has the standard on that page of the record.
I would think if you're just framing a legal question about what it means to support a finding, to me that sounds more like there is legally sufficient evidence such that if the agency ruled in favor of your opponents, we would not set aside that determination as unsupported by substantial evidence, rather than support in the sense of meets a burden of persuasion or compels a finding the other way.
Yes, I don't know that I don't necessarily disagree with Your Honor. I'm not sure that I've quite thought this question through, but I think that the way that the agency...
Maybe it doesn't matter if it's just words and phrases from your decisions, but...
It is, but the way that the agency has understood that is consistent with the way that the statutory process works and normal burdens in these proceedings. And it also helps to think practically what it would mean if the burden were not that way, if it were not required that you actually have to have enough evidence that would justify this finding of no reasonable harm. And it would essentially require the agency to continually redo its safety assessments anytime someone came and put into the record new studies about the safety of an established substance. And that would be an immense amount of work for the agency, and it would remove the stability of these authorizations that Congress intended them to have. Congress recognized that there are competing interests in this space. It's important to make sure that these substances are authorized and that the agency can conclude that they will be safe, but it needs to be able to do that and have some stability for those determinations because they're necessary for manufacturers and producers of food to be able to rely on those to help increase the shelf life of food and the robustness of the food supply in general. And so
petitioners come back and say, Congress intended FDA to protect the public from contaminated food and drugs, etc. So another way to look at this statute is it's sort of like a summary judgment notion that a petitioner has to come in and raise substantial questions. And then the agency has to hold a hearing and call in everybody who's relevant, the manufacturer, etc., and decide what to do. So what I hear partly from petitioners is the statutory language isn't that clear. It's not quite the same as the statute that was before the Ninth Circuit in the EPA case. The Alestra proceeding was different because it was an initial proceeding. But if I am a petitioner coming to FDA, I need to know what the rules are. And basically what I heard in the colloquy with Judge Katsas, although he raised an hour question and you're not raising that or relying on that, but it's sort of take your chances because in 2016, the agency was more aggressive on enforcement. Now, in this case, it's not. And given the serious stakes that are involved, I mean, here, in this case, the amazing thing to me is the petition comes in on 28 additives, and the manufacturer basically stops doing 23. All right, so then you've got these 5. And I think FDA agrees that the petitioners presented a lot of evidence, but it didn't stack up to the standard that FDA required, namely that FDA didn't have to do any more work. It could just accept what the petitioners had presented and say, we repeal the rule. And you make a lot of arguments about statutory construction, et cetera, industry reliance, floodgates, lack of budget for EPA to start all over again. And I don't take those lightly, but it does present a difficult situation for a petitioner who, having been clear as to precisely what the agency wanted, might have been able to come up with it. And at least took some guidance from earlier decisions by FDA, where some of the language is not as precise as maybe would help your argument more. So I don't see any case that has adopted this interpretation so far. And at best, we've been dealing with cases either with different statutes, different factual or procedural postures. And so to some extent, this is a question of first impression.
So the court hasn't specifically addressed it, Your Honor, but there's a wealth of sort of sources from the statute down to agency practice and the way that burdens normally work in these proceedings that demonstrates that what the agency is requiring is consistent with all those sources. So just to step back for a second, food additive petitions like the one that was filed here have only 2 outcomes. Either the petition is denied or the petition is granted. And when you're dealing with a repeal petition, that means the agency can either say, we are compelled to repeal this authorization based on your petition, or you have not met your burden of demonstrating that repeal is required. And based on
I understood it, it didn't bar the agency, and maybe I misunderstood, that the agency can deny, but before making that decision, it can hold a hearing to get more evidence, to clarify the evidence it has. It doesn't have to deal only with what the petitioner has submitted, or am I wrong? In other words, you either submit the 10 documents that FDA says are required, or we don't move.
So you're correct that hearings are permissible, Judge Rogers, but they do not serve the purpose that Your Honor is identifying. A hearing is not about additional fact finding to hear from new people and invite new evidence that's not already in the record. A hearing,
it's to clarify what is in the record. I mean, today we're hearing that, FDA said there were no animal studies. They say there are animal studies. That there were no relevant toxicity studies. They say there were toxicity studies. And I was trying to focus on this case. Well, there's a lot of expertise involved here, but that's not really the argument that's being made.
So based on the agency's scientific judgment and expertise applied consistent with internationally recognized guidelines, the agency determined that based on all the evidence submitted in the record collectively and looking at evidence individually, that the science did not support that evidence then ultimately shows no reasonable certainty of no harm. And the way that the agency uses hearings is if there is a specific, it's like summary judgment, a specific genuine dispute of material fact where the agency assesses something one way and they come in with an expert and they say, actually, you're doing the science wrong. Here's how this should be done. And if there is in fact that genuine dispute by what the agency is saying being directly rebutted, then a hearing might be appropriate to resolve that very specific dispute. That's not what we have here. If you look at the bases for rejecting the food additive petition, the non-human primate studies, the concerns with the UK diet study, those are very specific objections that were not directly rebutted by any kind of expert submissions in conjunction with the objections here. And I do just want to step back and recognize that this is just one step in the process of FDA's actions in this space. It authorizes substances. Their repeal can be petitioned for. The agency can reject that petition on the basis of not satisfying its burden. But that doesn't mean that the agency just sits back and does nothing. There is a post-market review process going on right now where the agency is looking at the data that it received in response to its request for information in 2022, and it's conducting a risk and safety assessment that will incorporate that data as relevant and ultimately issue an assessment which is part of the process in determining whether the agency is going to revisit the underlying safety determinations.
The agency pointed that out, I think, in its decision, and you pointed it out in your briefing. And if I can ask a question about that related to standing for a second.
Yes.
The shift to standing. So in a context in which the agency itself is saying that there's some stuff here that we need to look at, and we're doing that, trust us, we're looking at it. It just seems to me that the necessary backdrop is, hey, there might be some problems here. We're not saying that there definitely is. We're not saying that we definitely need to change the way we're looking at things, but trust us, we're looking at this because we understand that there may be some problems here and it's something that we need to look at seriously. If that's the case, then when a party comes in and says, the thing that you said that you're going to look at seriously because there's enough of a concern about it that you're going to look at it seriously, I've got some real concerns that I've got double the exposure to it that I otherwise would. Say triple the exposure to it that I otherwise would. And then against that backdrop, for a court to come in and say, which I think is the upshot of your standing argument, that, look, yes, we're looking at this. It's serious enough for us to look at. But as an absolute matter, the risk that you're talking about isn't serious enough for you to get into court. It's just not. It just strikes me that there's something a little bit unbalanced about that. And I'm not talking about the increase, because I think the increase here just seems to me to be pretty self-evident, because the increase part of it, their petition says, what we want you to do is just flatly just repeal the authorization. So the increase seems to me is just a difference between whether it's going to be authorized at all or whether it's just not going to be authorized. So there's a pretty significant difference between those. But on the baseline level of risk that you start with, whether that level of harm is significant enough and imminent enough and as an initial matter, it just strikes me that there's something a little bit off about saying, on one hand, that just isn't enough because it's out there a ways. You haven't shown that it's quantifiably significant enough. And then on the other hand, saying, yeah, we get it. We're looking into this because there's some real concerns here. I'm not sure what more we should require, especially when you fold in, and I'm sorry to go on and on, but especially when you fold in also that we're supposed to assume the merits in favor of the petitioner.
Yes, Renner. And I think you're right to note that there does seem to be substantial overlap here between the merits, because we are focused on the safety showing versus standing. And so I think for the reasons that we would say that they have not satisfied their burden on the merits, they also underscore why they haven't demonstrated standing here. But I think looking at their overall burden in the standing context and the specific background facts of what's going on with these phthalates, it just demonstrates that under this court's precedence for an increased risk of harm theory, they haven't shown enough. And I just want to quickly clarify, Your Honor was talking about increased exposure and how revoking authorizations will decrease exposure. We don't necessarily dispute that, but when you're looking at increased risk of harm standing, the concrete injury is not the exposure, it's the health harms. And so it's not enough to say their exposure goes down. They have to actually show that their substantial risk of health harms goes down, and that if the agency revokes these authorizations, they will no longer have a substantial probability of suffering those health harms. And it's just too difficult to do that in this context because we're talking about only 5 phthalates. It's not all the phthalates that are authorized.
But I mean, if there's risk of harm to begin with, then there's definitely less risk of harm under their solution than yours. That's just a mathematical identity.
Yes, Your Honor, but they still have to show, and looking at their brief and hearing their presentation, I actually haven't heard them to discuss at all that they have to have a substantial probability of harm.
Right. So
and
that's
I don't
the
think
baseline. That's the question, not the delta, but it's the baseline that there's got to be some baseline risk of harm. And I guess my question about that is, there's something that doesn't quite work about saying the agency thinks that there may be enough harm here that we need to look at this seriously. But what you're showing is just not enough harm. It doesn't matter. We don't have enough concrete stuff to say you've got enough harm. You've shown enough risk of harm in the record to allow you to go forward.
Well, I think it's in the context of what their petition doesn't ultimately show with respect to harm on the merits. And we're not saying that they have to prove harm. They have to prove no reasonable certainty of no harm. And because they haven't done that, it underscores the weakness of their standing argument.
But don't we have to assume on the merits that they would do that for standing purposes?
You have to assume that they'll prevail. But as we understand their theory, it's that that submitting some studies raising safety questions is enough. We understand their burden of what that actually has to show to be different than they do. But I just want to underscore also, Your Honor, that in this context, it's very different than, say, exposure to one source of hazardous waste, where there's one source of harm, understandable health effects, and you're not getting exposed to that through other means. Here we have phthalates, which they're just talking about the dietary exposure to 5 phthalates. Even if FDA revoked this, there are still 4 prior sanctioned phthalates that are authorized for food contact use. So this isn't removing exposure to all phthalates. It also doesn't do anything about their non-dietary exposure to phthalates, which comes from the environment and from many other sources, as the various items in the record here discuss. And also their declarations explain that they're not just worried about phthalates, they're worried about various similar chemicals that also have the same alleged effects. And so against that backdrop of this isn't removing their exposure to these phthalates, it's not addressing their exposure to other phthalates through food, it's not addressing their exposure to other chemicals, they can't show that it's these specific authorizations that are what's doing the work with respect to their health harms, and that there is a substantial probability because these specific 5 are only authorized in food. There will no longer be that probability if these 5 are revoked. It's a very difficult showing just because of the context that they have here. But regardless, the reasons that we think that their standing arguments are particularly weak are also the reasons that they have not succeeded in meeting their burden on the merits with respect to a showing of no reasonable certainty of no harm, and also that they're operating at this level of generality with putting things in the record and trying to point out individual issues with addressing specific studies that sort of ignores the overall context of the agency's safety determination. It's about comparing acceptable intake to exposure. It's about actually putting that toxicological data in the context of exposure. Any substance is potentially toxic at high enough levels. If you drink enough water, you could die. That's not enough to show that something is harmful. You actually have to do that work of showing that the exposure is what's going to make it potentially harmful. And they have not done that in their petition, and their objections don't remedy the errors that the agency identified.
Could I follow up just on standing? Maybe these questions are driven by similar concern as the Chief's. So our cases do seem to say that the absolute level of risk has to be substantial. How do we think about that or quantify that in the context of these latent exposure cases. I mean, right, if I think that I have a 1 in 100% chance of getting some sort of fatal disease from some particular exposure, I'd probably think of that as substantial, even though in most legal contexts, like 1% is not going to be substantial. Is that how we should think of substantiality under public citizen?
Yeah, I'm not sure that I can speak to a specific levels like that, Your Honor. I think it is the kind of thing that does depend on context, and we just fall back on the fact that in the specific context here and the confounding variables and the deficiencies in their merits presentation, that's the basis that we would say that there's no standing here. If there was a slam dunk petition that did all of the work and demonstrated that there is no reasonable certainty of harm, then our standing arguments, would either be non-existent or would look very different. But here we just don't have the basis to conclude that they've shown enough under what this court has described as the very strict showings of substantiality for this kind of increase of harm case.
Well, in our NRDC decision, authored by Judge Randolph, we answered that question. So there may be ways to distinguish that case, I don't know, but I mean, we did answer it, where there was a very low probability, but that was enough. And what I'm concerned about in your arguments now about standing is, and I don't think FDA did this here, but FDA can't moot a petition by taking the action that the petitioner has requested. All right. So I didn't understand FDA to be taking that position. It acknowledges that if there were studies that it found adequate to show that these 5 drugs, substantial probability that they are no longer safe, etc. And it addressed the merits of the argument. Its position was not that, well, it has these additives on the list and it's going to issue a notice of request, moots out the case, because FDA could have done this at any point. That's not how it treated it. And I'm concerned that if this court were to say that this case is moot because the agency has issued a notice or a request for information, there's no case or controversy before us. Petitioner's position, as I understand it, is they've met their burden of persuasion under the statutory language, and EPA, they say, has violated the APA, both as a matter of law and because it's been arbitrary and capricious in terms of how it addressed other cases. And the agency responded to those arguments. So if we want to cut this off at the beginning by saying there is no standing, it seems to me we have to massage, that's a gentle word, some of our precedents about what is sufficient to show standing in these increased risk cases. And maybe the court is going to step back. But I didn't understand that to be the argument that was presented to us here.
Yeah, so just to clarify, Your Honor, we're not trying to argue mootness at all based on the agency's other actions. And with the agency is engaging in this post-market review, which, is going to produce a risk and safety assessment. Unclear, what could ultimately come of that with respect to whether the agency undertakes future regulatory action. That's sort of a separate question. It doesn't mean that that's not the basis for saying there's no jurisdiction here. That's just the basis for underscoring that overall, the way that this process is supposed to work is that the agency puts these authorizations into place and does not get rid of them unless the evidence supports that decision, and the agency is doing the work to assess whether there's new evidence that was not in the record with respect to this petition that would require it to revisit its safety determination. With respect to standing, we think that our standing arguments here fall squarely within how the court explains standing in the public citizen cases and in the food and water watch case. Specifically, if Your Honor, if the court looks at the second public citizen case where the court assessed the declarations that were put into the record in an attempt to meet their burden with respect to increased risk standing, it shows the kind of heightened showing that's necessary that is not met here. And as I believe it was...
Did it overrule the NRDC case?
No, but it drew its standard.
Randall?
It drew its standard, specifically said that it was drawing its standard and how it applied it from both NRDC and mountain states. And so it was based on past precedent of this court, was trying to synthesize what it meant to satisfy an increased risk of harm standing analysis.
But remember, public citizen set up a two-pronged requirement. And Susan B. Anthony by the Supreme Court said you didn't have to show both. All right, so that's where we are now.
So the Susan B. Anthony case was about pre-enforcement standing, and
Yes.
The Food and Water Watch case, which postdated Susan B. Anthony and cited Susan B. Anthony, continued to reiterate the standard that we're discussing here. And so I think this court...
I agree, but it's not the two-pronged standard of public citizen. That's all I'm getting at. Public citizen said you had to do one and you had to do two, and then it sent it back to get some more information, and then the second case came.
So I disagree, Your Honor. I think Food and Water Watch actually does just recite the exact same standard from public citizen having the two prongs. It didn't need to address both of them because it determined that there wasn't a sufficiently substantial increased risk, but it did recite the exact same standard as public citizen.
What did it do about Susan B. Anthony?
I believe that case is really focused on pre-enforcement standing and not about the risk of an increased risk of harm of something happening. It was about whether potential future enforcement could be determined to be a imminent and concrete injury for the purposes of suing in advance of something being applied.
So let me be clear what your response to my colleague's question about standing was. What is your position? What is FDA's position on whether the petitioners have Article 3 standing?
So in this case, we think that based on how hard it is to show increased risk of harm standing in the context of under-regulation of a third party under this court's precedents, that they simply, based on the weaknesses in the substance of their petition, they simply haven't done enough to do that here. But as Judge Srinivasan noted earlier, there does seem to be a lot of substantial overlap in these questions with the merits. And so if the court disagrees or thinks those are entirely intertwined, it can simply just proceed to the merits in this case.
No, I don't think that's correct after Steel Company. I mean, often the court has to look to the merits to determine whether or not there is Article 3 standing, and does. All right? But that doesn't mean we can just say, well, you lose on the merits, so we don't have to do anything. So I'm concerned about this issue because I think this increased harm area is a very difficult area in terms of what does a petitioner have to show. And I understand FDA's argument about how it interprets the statute and why. But ultimately, after Loper Bright, that's a decision for us. But in any event, so your point is that because petitioners' factual showing in support of its merits argument, seeking repeal, was so weak Therefore, it doesn't have Article 3 standing because it can't meet these significant showing of substantial likelihood, et cetera.
In the context of this case, we do think that there's those issues substantially overlap, Your Honor. And so if the court doesn't have to
We've got a number
assume.
of cases in the commercial area where, you know, a factory doesn't have to close. A factory doesn't have to go bankrupt, but it can still have standing to come in and challenge an agency regulation that it says is harming it. And it may be wrong, but that's a merits issue. And we haven't treated those as an Article 3 threshold issue. And that's what I'm trying to understand here. I mean, all these people say they eat chicken. They're very concerned about this. They joined organizations, or they put up a lot of money for these organizations to pursue their interests. And they want FDA to do its job as they conceive it. And FDA isn't saying it's not going to do its job. It's just saying what you have presented to us is not enough under the statutory standard.
Yeah, we think that is, it underscores why they lack standing, but it also, because it is so in line with the merits in this case, it just demonstrates that they had this burden. The agency determined in the basis of its expert scientific judgment that they had not put in the kind of evidence that could have satisfied their burden in this case. And so the correct result is to deny the petition on that basis, and then the agency will proceed with its post-market review that it's already conducting in this space to look at new evidence and determine whether the safety determination ultimately has to be revisited.
Okay. Let me make sure my colleagues don't have any additional questions at this point. If there are no further ones, we'll hear from Petitioner's Counsel for rebuttal.
Thank you, Your Honor.
Thank you, Ms. Newmaster. Ms. O'Brien, we'll give you the 3 minutes you asked for.
Thank you, Your Honor. I'll endeavor to make 3 points quickly. With respect to standing, in response to Judge Katsas' question, the court affirmed in Food and Water Watch that this court does not require a quantitative analysis demonstrating a specific probability of future health harm to establish standing. Furthermore, in the Mountain States Legal Foundation case discussed in our brief, the court affirmed that relatively modest increments in risk are sufficient to support these types of standing theories where the risk of injury is serious. Here we are talking about permanent harm to children's brain development, the inability to have children, and other severe health risks for which a modest incremental risk is sufficient to support standing. The court also held that the existence of other factors contributing to the risk does not defeat standing. So government counsel's argument about the unfortunate presence of other chemicals that also contribute to these health risks does not undermine standing. Second, I want to note that the government is grasping for support for what are really ad hoc criteria that it applied to the petition in this case that do not have any foundation in the statute or the regulations. The discussion about having to compare an ADI to an EDI or comply with international standards, those are not in any statutory provision, regulatory provision, or even a guidance document that the government can point to. The government does not even require those specific demonstrations for approval petitions for food additives. And we know from the record here that the agency itself had nothing like the evidence it's demanding from petitioners to support its own safety findings for these chemicals. And it is fundamentally arbitrary for the agency to say, we haven't done enough to disturb safety findings that are based on radically outdated toxicity evidence and no exposure evidence. That is arbitrary. Finally, the promise of a future safety review on FDA's chosen timetable is inconsistent with the scheme that Congress established here, which permits petitioners to trigger a requirement for FDA to update its assessments through the petition process. And it's also cold comfort, given that FDA has been promising the public, Congress, and now this court for 18 years that it will update the safety reviews for these chemicals while we all continue to consume them in our food. FDA is now seeking this court's blessing to just keep kicking that can down the road for as long as the agency sees fit. And we respectfully urge the court not to give the agency that cover and instead to vacate the unlawful order that's before the court here. Thank you.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Thank you.
Case number 25-5239. Alignment Healthcare Inc. Balance versus United States Department of Health and Human Services et al. Mr. Kimberly for the balance, Mr. Starcher for the appellants.
Morning, counsel. Mr. Kimberly, please proceed when you're ready.
Good morning. Thank you, Your Honor. Appellant alignment in this case does not ask the court to break any new legal ground. The rule on which this case depends is straightforward. If an agency alone has access to relevant evidence or data, and a regulated entity raises a facially plausible, credible objection in an administrative review process, asserting that the data are wrong or contain or reflect errors, the agency must actually look at the data. This follows from Fox Television, among other cases. Fox Television tells us that courts must, quote, insist that an agency examine the relevant data and articulate a satisfactory explanation, close quote, based on that data. If an agency doesn't check the data, and it later turns out in an APA lawsuit in which the agency produces the data that it refused to review in the administrative review process, that the objection is borne out by that data, then the agency has violated the APA. And we know that from State Farm. Courts must reject, quote, an explanation for an agency decision that runs counter to the evidence before the agency. Fox Television and State Farm are two of the most clearly established foundational ad law cases on the books, and they are sufficient, we submit, to resolve this case. Now, the explanations that CMS gives to the court now on appeal differ entirely from the explanations that it gave to alignment in the administrative review process. In the administrative review process, it said the response rates reflected Spanish language engagement sort of fell within the normal range, and therefore we're not going to investigate any further. And explanation one. Explanation two, and in any event, we don't get involved in disputes between MA plans and survey vendors because we don't control survey vendors, our private third-party contractors. Before this court, the agency doesn't defend either of those positions. Instead, it offers two new ones, one of which wasn't even adopted by the district court. Its first explanation is to say that the question of how to administer the CAP survey in Spanish to individuals known to prefer Spanish is a question of absolute discretion for the third-party delegate, the survey vendor. And although the survey vendor may elect to take into consideration the preferences and directions and requests of the MA plans, they need not. It's entirely their discretion. Sort of a subset of that argument is that all the survey administrator then must do is ensure that Spanish language surveys are made available within the meaning of the protocols and specifications. And that's done simply by sending a pre-notification letter with instructions in Spanish on how to request Spanish surveys. Its second argument, and that was adopted by the district court at JA 81. Its second argument is to say that the survey administrator in this case, in any event, did follow alignment's instructions, but it did so after electing to use a especially quote unquote conservative record matching protocol that virtually ensured that a substantial portion of the individuals identified by alignment as preferring Spanish would not actually receive surveys in Spanish. Now, the clearest, I think, answer for this court as to those two explanations is simply that they weren't made in the administrative review process. And there are a few rules more basic than that judicial review of agency action is limited to the reasons that the agency gives when it took its action, and that post hoc litigation rationales are not a basis for upholding an agency action. But even on their own terms, those arguments don't hold water. We know from the protocols and specifications themselves that survey administrators must follow the protocols and specifications. Clear example of that, JA 148. We know too that the protocols and specifications state that MA plans.
Okay, I'm sorry to interrupt.
Certainly.
Just one second. We've lost the connection to
Okay.
Katsas. So
All right.
why don't we just take a brief recess to see if we can remake the connection?
Sure.
And if we can do that, we'll pick up where we left off and give you a little time.
Great.
Back up a little bit.
Stand, please. This honorable board will now take a brief recess.
Hello?
Dr. Katsas, this is Anne, the courtroom deputy. Can you hear me?
Yes, I hear you fine. I'm not sure what happened.
I'm not sure either. We just took a brief recess. I will tell the chief judge that we can resume arguments.
Okay.
Chef Rogers, if before I go talk to the chief judge, you could please turn your camera back on. Chef Rogers, this is Anne, the courtroom deputy. Can you hear me? Thank you, Judge Rogers. I will tell the Chief Judge that we can proceed.
Alaska case.
Stand, please. This honorable court is again in session. Be seated, please.
Okay, I think we're back connected now. So
Great.
you had made the point that you thought that the two agency rationales, that the two rationales in the briefs weren't reflected in the agency decision, and then you were going on to address the merits of them in any event.
Correct. So I'll start with the first explanation, Your Honor, which is that survey administrators have discretion to determine how they choose to administer CAP surveys to individuals known to prefer Spanish with Spanish language materials. We know from the protocols themselves that the protocols are binding on survey vendors at JA 148. We know from JA 167 to 168 that the protocols allow for MA plans to request of their survey administrators that they be administered to individuals who speak Spanish in particular ways. It says, and I quote, "Survey vendors may do any of the following at the request of the contract, including send a Spanish language questionnaire only in all mailings of the survey to enrollees known to prefer Spanish, according to language preference data received from the contract." That is what happened here. Now, CMS's position is that because the protocols use the word may, permissive may, rather than mandatory shall, it indicates that the survey administrator is free to disregard the request of an MA plan. But that can't be right for one of either two or both reasons. And the first is the consistency rule, and the second is the non-delegation rule. The consistency rule, which we briefed extensively in both the opening and the reply, relies on, for example, Con Ed against FERC, which is the idea that agency protocols obviously have to be applied consistently across regulated entities. And deviations in similar cases have to be explained with some relevant difference between the cases. And here there is no relevant distinction other than in CMS's view, the happenstance of which survey administrator an MA plan elects to hire. On CMS's view, one survey administrator could choose to always follow the requests of MA plans. Another survey administrator could refuse ever to follow those requests, and a third might pick something in between. So that's a straightforward, I think, violation of the consistency principle.
I mean, I think under everybody's view, you have to win on the other argument anyway, right? Which is, in other words, even if the government's position in this case is wrong on May, they've still got the fallback position that regardless, the agency didn't violate the protocols.
Well, yes and no. They've made that argument, Your Honor. I would say no, we don't have to win on the merits of that argument because once again, that is...
You got your argument that wasn't the agency's rationale to begin with.
Exactly. This is not our effort to play gotcha with the administrative record. If the agency had taken this position, which is basically alignment, you must prove a negative, prove that your survey administrator didn't do anything that it possibly could have to administer the survey in Spanish to Spanish speakers. We would have requested that the agency put evidence in the record to address each of the alternatives. We don't have, alignment doesn't have control over this evidence. It's all in the hands of either DataStat, the survey administrator, or CMS. Much of it, alignment isn't even permitted to see. And we would have explained why they were wrong and made the agency explain why it is changing its policy, because its policy always has been that survey administrators must follow, its practice, has been that survey administrators must follow the requests of the MA plans who retain them to administer the CAP survey. This is reflected, among other places, in the briefing in this case, JA 28, where in briefing before the district court, CMS itself said that MA plans, quote, may promote participation among non-English speaking members by providing the member with enrollee level language preference data, which is what alignment did in this case, and instructing the vendor to send translated surveys based on those preferences, which again is exactly what alignment did. Now, the point is, in response, DataStat then exercised additional administrative discretion in engaging in what it characterized in emails between itself and another third-party contractor, not CMS, as an especially conservative data matching protocol. But that runs into the same problems, because there's no question that this especially conservative approach to data matching substantially affected the number of individuals known to prefer Spanish who actually received materials in Spanish rather than English. It significantly depressed it by 10%. And it runs into the same consistency and non-delegation problems. What the Supreme Court said just a few months ago in Consumers Research is third-party contractors, I want to make sure this isn't another connection problem. Okay. Third-party contractors to agencies that help agencies administer the regulatory programs under their supervision must do so according to detailed rules, and they must at all times be subject to supervision and control by the agency, which is what the agency in the administrative review process in this case expressly disavowed. It said we have no control over these third-party contractors, and they are free to do as they like with respect to these questions of administrative discretion. So really, no matter how you cut it, there is no way we submit to justify the outcome in this case in a way that's consistent with settled ad law principles and the Constitution and its limit on non-delegation.
Let me make sure my colleagues don't have any additional questions for you at this point. We will give you a little time for rebuttal. Okay.
None from me.
Thank you. Mr. Starcher.
Your honors, and may it please the court, Jack Starcher on behalf of the United States. The district court here correctly granted summary judgment in CMS's favor based on two independent rationales. Those rationales are the same basic rationales given in briefing before the district court and that the agency provided in its decision below. And those two rationales are straightforward. The first is that the protocol that is the focus of this litigation and was the focus of alignment's complaints before the agency is by its terms optional, not mandatory. Hence, even if that protocol were not followed, that would not demonstrate a violation of any mandatory CMS protocol sufficient to cast significant doubt or significant enough doubt on the results of the survey in question. And second, and these are again independent, in any event, the record before the agency demonstrated that this optional protocol was followed. And I'll just, I think it's helpful to look at what that protocol actually says. And this is JA 168. So again, this is even accepting the opening argument that the may in this section actually is a must. The protocol says that vendor can send a Spanish language questionnaire only to enrollees that, quote, can be identified using one option, language preference data received from the contract. And there is no dispute that the vendor used language preference data received from the contract to send Spanish language only surveys to individuals identified using that information. In briefing before this court, the focus is particularly in the reply brief. I guess it's really only in the reply brief, but plaintiff didn't mention this at all in their opening brief. Focuses on the adequacy of this, of the explanation given by the vendor at JA 198 for why some individuals identified as preferring Spanish might not have or did not receive Spanish language only surveys, notwithstanding that data. But once we're at that point where we're so far beyond anything in the protocols that I just don't see any way that CMS could have been required to throw out the entirety of these survey results as a result of these errors. I do just want to briefly respond to this suggestion that any of this is new or that there was any sort of invention of new arguments that were not made by the agency in this months-long email exchange that appears in the joint appendix. And I guess I'd just point to the very first email that CMS sent in response to plaintiff's concerns, and that's JA 127. And there is a full paragraph in that initial response explaining to plaintiff exactly the point that is made in our briefing and exactly the point that the district court accepted, which is CMS protocols in this space are extensive. There are optional requirements and there are mandatory, there are optional features in the protocols and there are mandatory features in the protocols. And in that full paragraph, again, the very first response CMS sent, CMS responded and explained that CMS requires that, and this is a quote, at a minimum, Spanish surveys be made available upon request from members in response to the bilingual pre-notification materials. That's the mandatory requirement. And then the very next sentence, CMS says, please see page 50 of the protocols, which is the page we've been talking about so far, for details about actions, plans, and survey vendors may employ to promote or further promote participation in Spanish. And so this was presented in the very first email CMS sent. It was never disputed. And the discussion between CMS and plaintiff proceeded on the assumption, which was supported by everything plaintiff said, that they were focused on this optional requirement. And CMS, I think did more than it needed to and took those concerns very seriously. And over the course of the following, month or so, several weeks, responded in repeated detail with why it didn't think there were any concerns, even with that optional protocol.
I thought the point was that the fact that the may means that there was complete discretion wasn't something that the agency indicated in the back and forth.
So I guess the response to that, I would point to JA 117, which is, again, the agency explaining, quote, whether or not Spanish-speaking members received surveys in English despite their preferences is outside of CMS control. That is a response explaining that, precisely because these are optional, CMS doesn't get in, and again, this is a quote, doesn't get involved in how survey vendors implement language preference data. Again, I don't think you need to accept the may must thing, because even if plaintiffs are right that this is best read as a must, the agency then squarely asked the vendor, did you use this data? And the vendor responded, yes, we did. Here's how. And then CMS told alignment exactly that. And it told it twice. On J112, quote, as we noted, the survey vendor has attested that they followed the protocol procedures and used the preference data shared by you, the plan. And then again, on page J107, sort of in its final sort of statement on the matter, CMS said, regarding your third issue, our analysis have established that the sample is representative, that the vendor, quote, used the language preference information you provided, and then that there was nothing else about the data that independently gave any concern to the agency. So I'm happy to answer any questions, but I do think the agency has been consistent. These same basic principles have been presented at every stage of this litigation. And if we are right as to either of them, the grant of summary judgment should be affirmed.
I just have one question, which is this is on your primary argument, which, and I totally understand that even if we reject your primary argument, you still got the fallback argument. I'm completely understanding of that framework. But on the primary argument, to say that the may is discretionary, whether you agree with that or not, why does that matter if in fact the contractor then does accepts it? They didn't take up the invitation not to.
Yes.
They actually did it. And so if that's true, then why does it even matter that it's discretionary?
So it doesn't, I guess, but again, my reading of the agency's response to plaintiff during these many emails is that there were really these two threads, and one of the threads was there is, and I think this is just important background for this entire dispute. CMS has extensive protocols in this space and requires vendors to follow those protocols. Those specifically in the area of Spanish language access, even within that subspace, there are mandatory protocols and optional protocols all designed to make sure that Spanish language surveys are meaningfully accessible. And so I think this entire dispute sort of gets off on a strange foot, that the premise of plaintiff's argument, particularly in district court, was there was a clear violation of the protocols here. And the piece of this that we're talking about is optional. But I agree with you that the record here clearly demonstrates that the vendor did use the data.
They exercised the option. In other words, maybe they had the option, if your argument's right, not to exercise the option, but the option was exercised. And it just seems to me that then you're kind of necessarily at the last argument.
Yeah.
As to which you may well, you might prevail, but it's just that I don't know that the first argument does independent work in a situation in which the option's exercised.
Sure, I don't disagree with that.
Okay.
Yeah. And if there are no further questions, again, we ask that you affirm.
I think Judge Rogers is saying something, Judge Rogers, but I think you may be muted.
Yes, my apology. So how does it work in the real world? I'm an Advantage, Medicare Advantage insurer. And I contract with a vendor to notify within the jurisdictions I serve, Spanish-speaking people, and whatever information I have about what their preferences may be. The vendor says, thank you very much. I'll take that into account. And then the vendor sends to the Spanish-speaking residents, inhabitants, a letter that says basically, if you want to respond in Spanish, call this number. And that is in English.
So no, the pre-notification letter is required, and this is in the protocols, to be printed in Spanish on one side and in English on one side, explaining.
All hypothetical, is
Okay.
all English.
I see. So in that case, there would be a violation of mandatory CMS protocols. That vendor would have fallen below the minimum required by the protocols. I'll also say that vendor would be in violation independently of something called the Quality Assurance Plan. There's only one page of this in the JA. This
That's
is on.
okay. I think I understand what you're saying. So now the vendor sends a letter that is English on one side and Spanish on the other. But what they both say to the Spanish-speaking person is, if you want to take the survey in Spanish, call this number.
So that is, I think, what is required by the protocols for this pre-notification letter. I'll add that there are other sort of aspects of this system.
What I'm getting at is why doesn't the vendor necessarily take the least expensive option, which is my second hypothetical?
So again, I would point.
The letter in English and Spanish, but it requires the recipient to take another step. And certainly there are all kinds of human studies that show that if you want a response to something, don't ask somebody to take another step.
So I guess.
Because they're busy, they don't want to do it, they've got other things on their mind. So from the insurer's point of view, that makes no sense because it is going to suffer. So the question in the real world is, can an insurer dictate to a vendor that the vendor will only be paid by the insurance company if it sends the survey itself in Spanish to the people identified by the insurer as Spanish speaking?
So I guess two responses. First, and this is the same exact response that the agency gave below. To the extent a vendor and an insurance company want to enter into a contract that conditions payment on doing XYZ, I'm not aware of any control or insight or check or sort of review that CMS would do. So I think an insurance company
CMS
probably
would do what?
CMS doesn't review, as best I'm aware, the contracts between the vendor and the insurance company that's contracting with the vendor to conduct the survey. But I will, the part of this that CMS does have control over, and I will just point you back to JA 191. And this isn't really mentioned in the briefing in passing, but it's not really an issue. So it's not a focus in the briefing, but CMS, before any vendor is allowed to be a vendor that does this sort of sending out of these surveys, the vendor has to enter into a quality assurance plan that is approved by CMS. Data stats, again, just one page of data stats quality assurance plan is at page JA 191. And so I guess to go back to your question about the hypothetical sort of vendor who's taking the cheapest option or sort of cutting corners, that's exactly what this quality assurance plan is designed to prevent. The vendor represents and commits to CMS that it will take certain steps in order to ensure that the survey is administered in a way that will produce reliable data. And the page that you see on JA 191 is data stat committing for these two contracts to.
So if the insurance company sees a 15% drop or a 10% drop, or combine those two, 25% drop, and thinks, what's happened here? Based on previous experience, based on his information about the response rate of Spanish-speaking residents, and he calls or contacts CMS. As I understand CMS's position is, that's a matter between the insurance company and the contractor. We don't get involved.
So again, I guess this goes back to the Chief Judge's questions a little bit. I guess that's not our only position. Our position that is in any event, CMS did in fact contact the vendor in this case to confirm that it did in fact follow this protocol.
The vendor, of course, said he followed. I mean, what vendor is going to say I didn't follow the protocols and I didn't follow the contract? I mean, we're dealing with human nature here and human behavior. And what I'm trying to understand is to what extent CMS is just not concerned about these matters. And maybe it isn't.
I mean,
and that's the way it's going to administer the program.
I guess my response to that is threefold. The record reflects the quality assurance plan, which shows that CMS is concerned with how these vendors operate and ensuring that they are following these mandatory protocols. As discussed in our brief, this is point 2, the protocols include a lot of mandatory requirements. And again, we're in a really small universe of how does CMS make sure Spanish language surveys are meaningfully made available? Even in that small universe of this survey operation, there are, as enumerated in our briefing, a lot of mandatory requirements. You know, the website must, when you open the web survey, give you the option to proceed in your language of choice, and one of those must be Spanish. The bilingual pre-notification letter must be sent. And there's more. And then I guess the third response is the lengthy email exchange between CMS and plaintiff did not begin and end with, well, you've identified an optional, not a mandatory requirement, we're done. CMS then went on to confirm that the vendor did in fact do this, and looked at the data to make sure that there wasn't some reason to be suspicious that there was something wrong.
Did not look at the underlying data that indicated the 25% drop.
So
That's what I'm trying to understand here. I understand, I think, CMS's position about this is between the insurance company and the vendor. But asking the vendor, did you violate the law? And expecting the vendor to say anything other than, no, I did not. It's an assurance, I suppose, if in subsequent administrative proceedings or litigation, the agency is dealing with the vendor. But I just want to be clear about what the insurance company's options are here. And there really aren't any, as I understand it.
So
it doesn't know, it doesn't have access to the data, the underlying data.
That's
correct.
Whereas
CMS does. And a 25% drop isn't enough to look at that data. That's all I'm getting at.
Sure. And just to tease that out, the reference to drops in response rates from the 2024 to 2025 survey, CMS took those, and that's slightly distinct. I know plaintiff, I think, probably thinks that they're the use of the data and the drop in response rates are the same thing. But on the drop in response rates, the agency squarely responded to that. The agency said, here's the agency is the one that, as you say, gave plaintiff the data on this. And the agency looked at response rates and concluded, and I think this is an incredibly strong response. We looked at response rates for Spanish language speakers for these two contracts in particular. And for these contracts, Spanish language response rates were higher than average across all a similar sort of surveys that are done for these contracts.
Which what I'm getting at is the petitioner here incorrect in stating that CMS never looked at the underlying data?
What they mean by that is they never looked at the way in which the vendor was doing the matching, the name matching.
Right. Is it wrong about that?
Then I guess the record doesn't reflect whether the agency in fact did that, but no, I mean, they're not wrong about that.
There's no indication I could find that the agency said
that's right.
Did that. Okay.
But there was no.
My only point is, suppose when you look at the data, here we have a 25% drop. Suppose it's 50%. Suppose it's 75%. And the agency's response is, we didn't look at the data, but we asked the vendor, and this is not so abnormal that we need to do anything more. I just want to understand how this system works. That's all.
Sure. I mean, I can't say what the agency would say in that hypothetical, but I can again guess. I mean, as we point out, this is all optional. I think sort of lodestar underlying this entire process, if you look at 42 CFR 422.164, that's the regulatory provision explaining that CMS will always review all of the data that feeds into the star rating process and, quote, review the quality of the data on which the ratings are based, including accuracy, reliability, and validity of measures. So if there's ever a problem with survey vendors actions that rise to the level of giving CMS doubts about the reliability of that data, then that is something that the agency can and will respond to. And again, I think to the extent your question is getting at sort of well, did the agency here just sort of shrug and say, well, there's nothing to see here? There's, what is it, 30 something pages of the JA here, which is an extensive, over a month long back and forth in which the agency absolutely did not do that. It repeatedly responded and explained what it was thinking, what it had looked at.
No, but the only thing it didn't do, says petitioner, is look at the data that would have supported its concern about what was happening here. I don't need to pursue this. I understand your answer.
Thank you. If there are no further questions, I'll sit down.
Thank you, counsel. Mr. Kimberly, we'll give you 2 minutes for rebuttal.
Thank you. Your Honors, I'll start at JA 127. Mr. Starcher is correct that their CMS said there are optional ways of making Spanish language materials available to Spanish speakers. But it then says that alignment didn't avail itself of that option. The premise of this response, which was a factual misimpression, was legally that it's up to alignment to elect whether or not to make Spanish-only materials available to individuals known to prefer Spanish. And it said, you didn't do that. Alignment responded and said, actually, yes, we did. We sent this data to Datastat and we asked Datastat to match it in just this way. And that's when their real explanation came, which is at JA 112 and JA 117. At JA 112, they say, well, we looked at the results and the results are within the range of normal. But alignment works really hard at this stuff. They take these surveys very seriously. Star ratings are tremendously important to the Medicare Advantage program, and they push for administration procedures that drive up response rates because they know Spanish speakers respond more favorably for them. So they want to drive up those rates and they take steps to do it. So no surprise that their rates overall are above average. The point is at JA 120 to 121, our data showing that although the number of individuals who were sampled and known to speak Spanish went up, the rate of respondents went down. And so when CMS responded and said, well, we asked Datastat if they followed the protocols and specifications, our response was, yeah, I mean, okay, we get it, sort of along the lines, Judge Rogers, of your line of questioning. But when you look at the data, something's going on here. This doesn't look right. And CMS's response over pages of emails was constantly to stiff arm alignment and refuse to look at the one thing that would have answered the question, whether there was a data administration error. And now, having filed a lawsuit and seen the data under an attorney's eyes only protective order, we see that there was an administration error. That, we submit, again, is all that we need to win this lawsuit. And the idea that CMS can simply step back and say, well, we don't have any control over this third-party contractor is just not consistent either with the consistency rule requiring it to treat similarly situated regulated entities the same way. And it's also inconsistent with the non-delegation doctrine. And we submit, Your Honors, that the district court's decision should be reversed.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Case number 25-5111. Uintah Indian Tribe of the Uintah and Ouray Indian Reservation appellants versus United States of America et al. Mr. Rasmussen for the appellant, Ms. Frey for the appellees.
Good morning, counsel. Mr. Rasmussen.
Good morning.
Proceed when you're ready.
Good morning, Your Honor. May it please the court. My name is Jeffrey Rasmussen. I am the attorney for the Ute Indian tribe of the Uintah and Ouray Reservation. And with me at council table is co-counsel Mr. Patterson. And also here is a representative from the Tribes Council, Cleveland Murray. We are here today on what could be the last, I think, large Indian law land case in the country. And it has a kind of a unique history of why it still is in existence. But we are here now to determine whether the tribe had compensable title to land on that is currently owned by the United States on the tribe's existing reservation. And that existing reservation is it's about 1.9 million acres. The United States still owns 1.5 million acres of that land. And under the proper interpretation of the 1880 Act that we discuss at length in our brief, the United States was the broker for sale of that land. And it had then the duty to place proceeds from those sales of that land that was set apart for the Uncompahgre band into trust. And the estates in Indian law are really very different from the estates in English law. And as we all learned in law school, there's all sorts of complicated estates in under English law. Indian law has some of that same similarity in that it's really complex. But what we have as agreement in this case is if the tribe had what we now refer to as compensable title, which is the lowest level of title that a tribe can have, that if it has compensable title, then that land can be restored under the Indian Reorganization Act. And so the issue is compensable title. And so the United States cites, for example, some dicta from Supreme Court cases where it's talking about ownership. That's talking about a different type of title. That's talking about trust title. And that's not what we're talking about here. What we're talking about here is compensable title, the lowest level. And so we look at the 1880 Act. The 1880 Act says that the tribe has compensable title. It defines, it's not using that term because that term is not used at that point in time in 1880, but that the tribe has, this land will be set apart for the tribe. There'll be a boundary for this reservation. The president will create this reservation and create a boundary for it. And then the land that is so set apart, which is the Uncompahgre Reservation, that land will then be like public lands except for that the tribe has the right to the proceeds from the sale. And that is then what later becomes, under the Indian Reorganization Act, compensable title. That is the definition of it, which is if the United States owns this land and it was the broker for sale of the land to non-Indians, as it was here, and then it can't sell the land, what do you do with it? And the Indian Reorganization Act says, well, if they didn't sell it, they have the authority to give it back to the tribe because it never sold. And here, the Uncompahgre Reservation, as we discussed in our brief, it's a very, very remote area. It is probably the most worthless land in the United States as far as agricultural uses or farming or irrigable lands. We've got 1.9 million acres, and not more than 3% of it is irrigable even. None of it can support a crop without irrigation. It is barren, high desert rock. The United States at the time, that's why they put the Uncompahgre out there. But then we found out later that it had oil. It had significant oil. It has one of the better oil fields in the United States. And so the United States said, oh, well, we'll just keep that. We'll keep that land. We didn't sell it. We'll just keep it. We'll keep the money from it. And that's why we're here. So the plain meaning of the statute is one of the two central issues in this case. Does this statute say that the tribe has the right to the proceeds from the sale of the land that was set apart? And the statute just explicitly says that, which is we really expected we would be on the other, at the other table when we got up to appeal here.
But for, when you say the statute just explicitly says that,
Yes,
so you're talking about the 1880 Act.
the 1880 Act, right?
Yeah, and for it to explicitly say that, then you'd have to conclude that the relevant corpus of land is not the Colorado land, that it encompasses the future, the Utah land that had yet to be demarked.
I don't think you have to say that. What you have to say is that the Uncompahgre was set apart. And when the statute refers to the land so set apart, the tribe will have compensable land title to the land so set apart, that then means that if they set apart the Uncompahgre outside of Colorado, that's the compensable title attaches to that land. So the United States, really at oral argument in the court below, latched onto a footnote in the M opinion that's under review, where the M opinion says, you know, this could be more properly understood to refer to the Colorado lands. First of all, we don't agree with that. And we discussed that in our brief. But second of all, that isn't the issue for the statutory interpretation in this case, because what we're talking about is the statute says the land so set apart, and the president is to send out a commission that find the land that they're going to move the Uncompahgre to. And at this point in 1880, and this is where the district court also got confused. At this point in 1880, that's what a reservation is. It is a line between the tribal members, and non-Indians. And non-Indians cannot cross that border, and tribal members can't cross that border either. It is to separate them. And that's what it was in 1880. And so the district court pulled in later concepts to talk about what happens a generation later or 10 years later, when we start having this concept of allotment really coming to fruition. But in 1880, that is still what a reservation is. So the president sets apart the reservation, says, this is the land I'm setting apart under the statute. Here it is. Move them to that. They're moved to that land at gunpoint, to this barren, rocky land. And they're told, this is your new reservation. And that reservation still exists today. And that it is that reservation that was set apart by the president, and there's no act of Congress that ever then revoked that. So the land that was set apart is the land that we're talking about here today. Whether there would be a right to compensation for land in Colorado, we view as a wholly separate issue then. And where the district court then said, well, if it's the land in Colorado, it can't be the land in Utah. We disagree with that, because the statute is referring to the land that is set apart. The land that is set apart is that land in Utah. So our view is that the statute itself is very, very clear. But I wanted to also—
Let me ask you on that point, though. When you look at the text of the statute, isn't it equally clear that it's talking about Colorado at that point?
No, I don't believe it is equally clear. I think that when it's talking about the land that is set apart, it is talking about the land that is going to be set apart for these two reservations, the one down for Southern Ute and the one for the Uncompahgre. That's the land it's referring to. There are other provisions that are—
Let me just ask you, counsel, so I'm clear.
Yeah.
The tribe was in one part of Colorado that it liked very much. All right.
Yes.
Then the government commissioner on Indian Affairs wanted to open up that land. So it had to find another place for the Indians. So it found this other place in Colorado, this barren rock place. And that's what the 1880 Act is talking about, isn't it?
No.
I mean, I know it has a reference to Colorado.
Right.
Or elsewhere, but.
Right. The act itself is referring to not barren land but it's referring to the land that is probably one of the more productive agricultural lands in Colorado, where Grand Junction is today. So it's referring to, we're going to move you to the Grand Junction area or to land in Utah. But as everybody is sort of recognized, that was more of a pretense of, oh, we'll move you to Colorado. Because when the commission comes out there and looks, they say, oh, there's no agricultural land here in this area that's now farmland in Colorado. So we're going to move you to the Uncompahgre. And that was relatively clear to everybody at the time that that was what was going to happen, because the Colorado was adamant that the Utes had to be removed from Colorado. And so what we have is there's a reference to land in Colorado or Utah. And once that reservation is established there, then that compensable title attaches to that reservation.
And
so
the question is, what does the word there mean? And you say it means Colorado land.
No, we say that the land, it's the land that is set apart based upon that 1880 Act. So it is the land that they're going to move the Uncompahgres to. And they only moved the Uncompahgres then that one time. They moved them from Colorado to the reservation in Utah, and it is that reservation that is established.
Okay, then I've got the facts wrong.
Okay.
I thought the tribe was in Colorado, which was very desirable for the tribe. Then the government, the federal government, decided it wanted to move the tribe elsewhere in Colorado. And it did move the tribe, or it expected the tribe to move to Colorado. And the tribe basically said, no, we don't want to go. And then Congress came along and authorized the Commissioner on Indian Affairs to set aside these allotments, but they were going to be in Idaho.
Utah.
In Utah.
Yeah.
So I thought there were 3 stages here, not just 2.
No, there were only the 2. So they were in the areas in Colorado that was part of their reservation in Colorado. The statute said, the 1880 Act says, we're going to set apart a new reservation for you. You're being kicked off this reservation. We're going to set apart a new reservation for you, and you are going to move to it. And then the Commissioner of Indian Affairs, they send out their survey team and they say that new reservation is going to be in Utah. It's going to be the Uncompahgre, which is still there today, the Uncompahgre Reservation. And that's where they then move them to. And so that is why that is the land that was set apart in compliance with that 1880 Act. So it was just the 2 places. Colorado, now we're moving you to Utah. I did want to briefly touch on one other issue besides the plain meaning, and that is the Indian canons. And here we've got the 1880 legislative history. We've got the 1882 proclamation. We've got the 1887 Act that is premised on the tribe having compensable title. We have the 1891 and 1892 Acts that didn't pass regarding Gilsonite that again are premised on the tribe having compensable title. We have the 1894 Act, which is again premised on the tribe having compensable title. It says that to allot this land, we're going to have to reach an agreement with the Ute tribe, and that's then based upon compensable title. We got the 1897 Act, which doesn't contain the language taking the reservation. So in 1880, under the Indian canons, the concept is if there's ambiguity, it's interpreted in favor of the tribe. We've got this string of acts right afterwards that is all premised on, and the 1880 legislation itself couldn't be clearer. This is all premised on, we can't just take a tribe, make them landless. We've got to give them compensation. So that's why the Ute tribe also understood the legislation under the Indian canons to be that they would have compensable title to this land. And the United States kind of alludes to Skidmore deference in its brief, doesn't actually talk about it, but does cite it in their standard of review. This court has held that even the Indian canons even trump Chevron deference, or trumped Chevron deference, I guess I should say. And Skidmore deference isn't really even a deference. So again, what we've got is the agency is trying to rely on its own analysis rather than the statute, and is trying to actually rely on its prior, really the core of its argument really goes back to just an anachronism that they previously argued the Uncompahgre Reservation did not exist. And then they wouldn't have had to restore it under the IRA. If there's not a reservation, it doesn't have to be restored. So that was how we got here, was that history. And now they admit the Uncompahgre Reservation still exists to this day. They finally accepted the Utah decisions, and that gutted their rationale, but they won't give up because this land is worth a lot of money now. They didn't think it was. Thank you.
Thank you, counsel. Make sure my colleagues don't have questions, additional questions this time. We will give you a little time for rebuttal.
Thank you.
May it please the
Sprague.
court, Mary Gabrielle Sprague for the United States. The statute that Mr. Rasmussen is describing is not the 1880 Act that was passed by Congress. Just to begin with the fundamental question Judge Rogers asked about the scheme, she's absolutely correct. The Utes were in the mountains of Colorado, this area near Grand Junction, Colorado, at the confluence of the Colorado River and the Gunnison River, was at the western end of what they claimed to be their homeland. And they were satisfied to go to that area, which had fertile land for farming. That was their expectation from all evidence. That was Congress's expectation. There were people calling to remove all the Utes from Colorado and send them to Utah or elsewhere. But that's not what Congress decided. Presumptively, the Uncompahgre Band could remain in Colorado where they wanted to be. What they expected was what the 1880 Act provides, which is that the commissioners, first of all, who are appointed by the president, would do a census of all the members of the band. According to the 1880 Act, depending on your age and your family status, you got certain acreages for your allotment, either 160 acres or 80 acres. So with the census and this specification of the acreage for allotments, the commissioners could decide how much land they needed. They would then look for that land, presumptively for the Uncompahgre and the Grand Junction area, but if not, then in Utah. And the land that was to be set apart was enough land, sufficient land for the acreage needed for these allotments. And then once that land, the sufficient acreage for these allotments was set apart, then they would draw the internal boundary lines and assign the different parcels to the different members. The other type of land that was to be set apart were relatively small parcels for agency buildings, schools and such that would support this new agricultural community of Uncompahgre Indians. So that was the scheme. That is what is written into the statute. It came as a surprise to the band that they were going to be relocated to Utah. And this was a result in 1881. The commissioners looked around. They said there was not sufficient land where they wanted to live in Colorado. The tribe has called that a fraud. In any event, but in writing this report, the Commissioner of Indian Affairs for the Secretary of the Interior said, well, we're going to take them to Utah, but it's rough going there. And so we're going to set apart a larger parcel of land within which these allotments that would be made. It has been the consistent position of the Department of the Interior that that executive order reservation was a temporary arrangement to allow the Uncompahgres to get settled and the land to be allotted. Now, the 1880 Act is all about allotment. Nowhere in the Act does it say that a new replacement reservation would be provided for the Uncompahgre band. The idea was to terminate the common ownership of a tribe for its members and replace it with individual parcels for the members, individual allotments. And this scheme has twice been described by the Supreme Court interpreting the 1880 Act. In 1947, in Confederated Bands of Ute Indians versus United States, and in 1971 in the Southern Ute, United States versus Southern Ute Tribe or Band of Indians. Confederated Bands is 330 U.S. 169. The Southern Ute case is 402 U.S. 159. And both of those cases surveying the history of the Colorado Reservation and interpreting the 1880 Act held that the Confederated Bands held compensable title only to the 1868 Treaty Reservation. As we said in our brief, quoting, the only lands for which Congress agreed in 1880 to compensate the Indians were those that the title to which the Indians then released and conveyed to the United States. They could only release and convey the lands that belonged to them, and only the lands given to them by the original 1868 treaty belonged to them. And on the tribe's point of the applicability of the Indian canon, it's well established that that does not change. It cannot be used to change the clear meaning of Congress. And the Supreme Court held that the 1880 Act was clear and said at page 179, their alleged understanding can't be imputed to Congress in the face of plain language and a rather full legislative history indicating that the 1880 Act neither conveyed nor ratified conveyance of these lands. While it has long been the rule that a treaty with Indians is to be construed so as to carry out the government's obligation in accordance with the fair understanding of the Indians, we cannot, under the guise of interpretation, create presidential authority where there was none, nor rewrite congressional acts so as to make them mean something they obviously were not intended to mean. The tribe's premises it puts forward of how this act operates is simply incorrect. Their premise is that the act directed land to be set apart for the Uncompahgre band in Utah for a reservation. That there is no statement to that effect in the act. It was all about allotments. It was terminating tribal ownership, replacing it with individual ownership. The tribe says at reply brief 12 that the concept of allotment was vaguely referenced in the act. That's just not true. The agreement details the specifications of the allotment, as I said, the census to be taken, how many acres of agricultural land, how many acres of grazing land, depending on your age and family status. The only reservation, reference to reservations in that act were to the Colorado Treaty Reservation and to the Uintah Reservation, which is west of the Uncompahgre Reservation in Utah, which is where the White River Utes were being relocated. The White River Utes were blamed for the Meeker Massacre, and Congress decided they would be removed from Colorado and relocated on the Uintah Valley Reservation and given allotments there. But otherwise, the Uncompahgre were going to stay. Presumptively, the Southern Utes would stay presumptively. Because of later history that we can't get into today, the Southern Utes still occupy the south part of Colorado, along with the Ute Mountain Utes. And the land, the second part of their premise that's false is that the land that was to be set apart, these allotments, were not going to be sold. The point was those were the lands, they weren't going to be sold by the government. Those were the lands that the individual members would keep. And again, the 1880 Act specifies how that land would be managed. Those allotments would be inalienable for 25 years. That's to allow for the time for the supposed transition to civilization, agricultural life. The act provides that after 25 years, and that would require apparently legislation to provide for patenting, after 25 years, the individual members would get fee patents from the government. At that point, the members could then sell their land if they wished, and the members would keep the money. But there's nothing anywhere in the act that says land would be set apart for the band. If that land were sold, it would then go to the band.
Okay.
I mean, there were many other details of Mr. Rasmussen's presentation and the tribe's brief that I believe are incorrect. I'd like to point out one that's not as apparent. So in the reply brief, Mr. Rasmussen was talking about the 1894 Act, which is an act which provided, because the original allotment didn't proceed as expected, Congress again in 1894 passed an allotment act for the Uncompahgre Reservation. And in the reply brief, it argues that the 1894 Act, Section 22, directed the commission to be appointed by the president to seek an agreement through which the tribe would relinquish all interest in the land on the Uncompahgre Reservation. This is in the reply brief, page 22, talking about Section 22 of the 1894 Act. And that is at 28 Stat 337. As Mr. Rasmussen said today, that supports the idea that if you had to get the band's agreement for the allotment and the disposition of the unallotted lands, that suggests an understanding that the tribe had compensable title. But Section 22 expressly applies only to the Uintah Indian Reservation, the area to the west of the Uncompahgre Reservation. It says nothing about the Uncompahgre Reservation. And as we explained in the brief, the Uintah Reservation, there is trust title, beneficial title, compensable title. They're all the same thing for this purpose, because there was an 1864 statute that confirmed the 1861 executive order. So setting aside the Uintah Valley Reservation. So there's no question the Uintah Valley Reservation required that there was this title, but the 1894 Act, sections 20 and 21 address the Uncompahgre Reservation. And there is not one word in those sections requiring any agreement by the band for either the allotment or for the disposition of the unallotted lands. And that's because Congress knew of the difference between the Uintah Reservation and the Uncompahgre Reservation. The Uintah, they had beneficial title, trust title, compensable title. The Uncompahgre Reservation, they were never granted that.
Let me make sure my colleagues don't have any questions on that score or any other that you've gone over. Okay.
Thank you.
Thank you, counsel. Mr. Rasmussen, we'll give you 2 minutes for a rebuttal.
Thank you, Your Honor. One of the key errors in the United States argument is their argument basically that the 1880 Act accomplished allotment. It did not. It contemplated subsequent acts of Congress. And as we cited, I believe it's page 201 of that statute. It contemplated that allotment would only occur after there were these subsequent statutes. Allotment wasn't a thing in 1880. This was kind of, oh, we're trying to flesh out how we'll do this. 1887, Congress passes a law for allotment, the General Allotment Act. Then Congress then says, go to the Utes and see if you can get an agreement to get them to relinquish their homeland in Utah. So that, and as we discussed on our brief, the Supreme Court has always said, well, Congress was always intending to get rid of tribes completely. The whole of United States history until, well, almost until the 1950s, 1960s. So that was, but we'll never interpret the act of Congress to do that until there's an act of Congress that actually does it. And that's why in the 10th Circuit, the United States made this argument about the 1894 Act, and the 10th Circuit rejected it. It said, no, that isn't sufficient. They had the land, and this 1894 Act is not sufficient. This 1897 Act is not sufficient. And so those were based upon the contemplation that the tribe had the compensable title to that land. The United States keeps saying this was a temporary arrangement, but that's the point, is that Congress may have thought in 1880 it was a temporary arrangement, but they never then passed the subsequent legislation that was required to take it. And that's why the tribe still has that compensable title to that land to this day, because it was set apart for them. And under the Indian canons, given that the United States is quibbling about the 1894 Act, but given that all the other acts that they don't dispute before that, that were based upon the tribe having compensable title, the Commissioner of Indian Affairs saying the tribe had compensable title in 1892. For this court to say it's clear that the tribe did not have compensable title, when everybody back then, the learned people studying this, said that the tribe did have compensable title for those first 12 years at least, even if the United States were right about 1894, and we don't believe they are, that would be under the Indian canons of construction, the required analysis.
Thank you, counsel. Thank you to both counsel. We'll take this case under submission.
Stand, please. This honorable court has been adjourned to Thursday, February 5th at 1:30 p.m.